Hi, good afternoon, and welcome to episode number 21 of At Your Service with Haber and Martinez. Ed and I are here today to talk about what I have entitled Idioms, Adages, and Proverbs. If any of you read my intro promo that I put out on social media today, I actually indicated that I should have added maxims into our title because actually it does fit nicely. Unfortunately, I couldn't find an illustration that had all four, so I abbreviated and left maxims out. I hope that Maxim, and I'm not talking about the magazine, but I'm hoping that Maxims forgive us for my omission. It was intentional, and unfortunately, it was due to a lack of ability to find a good enough illustration. However, I also want to point out that we're not talking about tenets or aphorisms because those don't apply to what we're trying to do today. But
You
what
do
Ed and I,
realize we have just lost half of the audience, including me, who has no idea what those things mean.
well, study English, bro. Um,
Why would I
what
study
can
English? It's only my first language.
what can I say? I'm the grammar police.
I
So
see
no,
that.
it's one of the things that motivates me and gets me fueled up. I like etymology, and I like words, and I like language, and I like puns. Um, Although I'll hold back on some of my punnier puns.
Yeah,
Uh,
please.
but what what we discussed was there's so many of these sayings. Let's just call them sayings
There
that
you go.
are in everyday life that we hear, and they really do. They're not just a parent talking to a kid or a friend talking to a friend or a therapist talking to a patient. They do have real world application. Many of these things have real world application to criminal law, or as Ed and I like to say, our favorite trifecta, cops, courts, and constitutions, right? Um, so we can hop in at any time. I list a whole bunch of them. I guess we could kind of run through them in no
Okay.
particular
But
order.
before you go in there, I just want to point something out. A lot of these sayings, quote unquote sayings, Michael, they come from an era where people were big on storytelling, big on folk tales, Aesop's tales. They come from a time period where
You mean that guy where the A is silent?
yes. So I read a little bit. I may mispronounce names, but I know what I'm talking about. I just mispronounce things all the time. I commit Bidenisms all the time because I think we should start that. We should start calling them Bidenisms. Um, for people forget about Dan Quayle, so we can't use Quayle anymore. But they seriously they come from a time where people would listen to their elders, and the elders would come up with these little sayings for the younger group to understand what they're really trying to say. For example, like the boy who cried wolf, right? You tell a kid, hey, don't be saying stuff that happens because if you keep doing it, eventually nobody's going to believe you. It's much more effective when you're talking to a 12-year-old to say, tell them the story, and they get all enthralled. They start paying attention. And they look at this little boy who kept saying the wolf was going to get him and he was lying because he thought it was funny to see everybody just scramble. And then when the real wolf came, he ate him. That, and you're 12, sticks in your mind. You're like, oh shit. Yeah, it's not funny when he got eaten alive by a wolf. So these sayings, while we kind of gloss over them because it's a different era, they really have some real world punch to them,
It's
and they really mean something.
you're 100% spot on. And I actually, as I'm thinking about it, didn't they used to show Aesop's fables before cartoons on Saturday mornings?
Yes, they
I mean,
did.
this was stuff that was, and there really was a method to the madness. I mean, you
Absolutely.
some might call it indoctrination, but I think it's a positive indoctrination. And these are the types of things as we run through them and talk about their application to cops, courts, and constitutions. These are the types of things that parents taught kids and that parents should teach kids because, so, well, starting off with one, right? An ounce of prevention, right?
Ounce of prevention.
How's that saying go? An ounce of prevention is worth a pound of cure.
Correct.
And that's kind of what we're talking about right now. If you're able to plan in advance and think of things in advance and have foreknowledge, then there's a good chance that you won't step in your own crap and avoid a lot of potential problems. We have a saying, or actually an acronym that we use called the Law of the Seven P's, and it's kind of a play on the Boy Scouts motto, "Be prepared." Right? It's prior proper planning prevents piss poor performance. And basically what it means is if you have your act together, you have some good indicia of what it is that's coming down the road, right?
Right.
If you know that you're going to be possibly spending the night out at your friend's house, pack your toothbrush, lest you don't have one, right?
Or
So
you don't want to brush your teeth, which maybe you may not want.
Gross, but possible. So I think, yeah, I mean, these are the types of things that, again, these little adages that we'll get into can be sayings can be very helpful. So
let's get into the first one. So
let's start with the first one. You're judged by the company you keep, aka birds of a feather flock together.
AKA in Spanish, for our Spanish listeners, dime con quién tú andas y te diré quién tú eres. Tell me who you hang out with.
What he said.
Who you are. Well, I'm translating for you. The saying in Spanish is, tell me who you hang out with and I'll tell you exactly who you are. So now, how does that translate to the criminal world and when we defend our clients and what happens to our clients? Go ahead, Mike.
Are you asking or you feel?
Yeah.
Okay.
Yeah,
so
go for it.
So I'll give you a great example. You are in a car with people in a place where you are in just patently suspicious, okay, to the blind eye. Naturally curious police officers, even though they don't have probable cause or reasonable suspicion, do have a sixth sense. And oftentimes that sixth sense is spot frickin' on.
Can I interrupt for a second on that? Let me just pet peeve. Talking to my clients will tell me things like, oh, come on, I knew that guy was up to no good because of what he was wearing or the car he was driving or the way he was standing. And I always tell my clients, you do realize that cops are not immune to the same shit. You realize
not only are they not immune
to the same things you do.
Not only are they not immune to it, they're actually attuned to it. That's what keeps them going.
And alive. And keeps them alive in many instances.
So that would be one example of just being in the wrong place at the wrong time, right? I mean, if you're with certain people, you are going to be considered as part of that group. Even if you have no knowledge or intent or desire to participate, and even if nothing is going on necessarily, it's the imagery that conjures up reasonable suspicion or probable cause, or even just a mere, and what is the word? Mere unarticulable hunch.
Right. Well, not a hunch, suspicion, because they can't use hunch. That's a
bad word. They can't, right, but I'm using it intentionally because the truth is they do use it.
Of course.
If they can't substantiate the hunch later, then we win. But if they can substantiate the hunch, which sometimes they do after the fact, and then they word it in such a way as if they had done that beforehand, right? Because they're not stupid. They know the rules.
Well, actually, I trained at the academy. I'm going to tell two quick stories. First one is this. I trained at the academy for years when I was a state attorney. And then after I left for a couple of years, they called me back still to train. And I used to get into this with them. I used to tell them, listen, you can't call it a hunch. But in my training and experience as a prosecutor, I found that it is a hunch, but it's articulable. The problem is that when you do it for so long and you could just sense, right? You're like, I have a sense. So I always used to tell them, right? That's what you guys know. You have a hunch. You have a sense. There's just something that you could just tell. And they're like, yeah. I said, okay, what is it? They're like, I don't know. I said, I used to give them this example. Give you an example. Suppose I'm walking up to some guy. I see the guy. When he makes eye contact with me, I see him turn a little bit to his right, and I see him pull his shirt and pull it down. I immediately talk to everybody in the room, all the cops. I say, why do you think he did that? Oh, he's probably got a concealed weapon. I go, exactly. How'd you know? Well, I don't know. I said, well, I just told you.
Training and
experience. He made eye contact. He turned and pulled his shirt. That's what you write. You don't say it was a hunch. You literally write what alerted you. Turns out he didn't have a gun. Okay. Turns out he had a gun. Look at that. His behavior is what you guys are calling a hunch. But this is what we all base it on. Going back to tell me who you hang out with and I'll tell you who you are. I was in high school playing baseball. One of the guys on the team, Michael, what a nice guy, man. He was a wonderful friend. Just an amazingly wonderful human being. I can't stress enough how good of a guy this was. What a great friend, a real loyal friend. But he had to smoke pot just 24/7. I've never played with a guy like this. He actually hit better when he was high. If he wasn't high, he couldn't hit. Couldn't hit water if he fell out of a boat. But when he was high, he was like a 400 hitter. So I remember we were at a game and we were at a park. It was in high school. We were playing in high school, and apparently we got the wrong address. I don't know what happened. And everybody had to scramble and get to the other park quickly. And he wanted to give me a ride. So the first thing I asked him before I got in the car, I looked him right in the eye and say, tell me you don't have pot in your car. Why? Because I realized if we get pulled over and there's pot in the center console, that cop doesn't know my buddy. He doesn't know me. He's not wondering whose pot is it? Probably both of them. Because why wouldn't it? Doesn't it make sense that if he's a major pothead, his friend would also be a major pothead? And so now I got to sit there and explain why. No, I know that's what he does. He's a good friend, but I never put myself in a situation where it could get me in trouble.
Hey, Martinez, I'll bet you if he had a center console full of gummies, you'd have a different opinion.
Listen, back then, pot was illegal. Whether you had a medical marijuana license or not, there was no excuse for having pot, and I was 17 years old. There's no excuse. My ass would have been in juvie.
All right, let's go to another similar one that butts right up against that one. If it looks like a duck, if it walks like a duck, if it quacks like a duck, it must be a duck. That's kind of along the same lines as you're judged by the company you keep, right? I mean, this is a visual and sensory perception that leads to a logical conclusion. Right. And so when you're talking about cops, you always have to bear in mind that they look at the world through a very unique prism, a very different prism than most, let's call it non-law enforcement or civilians, lay witnesses look at it through. So when they see something that looks or appears or sensories to them to be suspicious, their antennas are going up and they're going up fast. They're going to assume and presume you guilty. The one thing that they don't teach at the police academy is the Fifth Amendment. Other than how to read people their rights, you're not presumed innocent as a police officer. You do not presume people innocent. In fact, if anything, you do the exact opposite. You presume them guilty and let them prove to you that they're not. For example, when you get pulled over and the officer smells alcohol on your breath, he's going to give you or she's going to give you or try to give you roadside sobriety exams. Why? Not because they don't have anything else to do, not because they're looking for a laugh, but because they're actually giving you an opportunity to prove that they're wrong. Now, whether that...
In fairness to my law enforcement DUI friends who I love dearly, I've dealt with thousands of cases, Michael, especially as a prosecutor. I don't know if they do it intentionally or not, but their attitude is not, let me give you the roadside sobriety test so you can prove that you're not DUI. On the contrary, they're looking for excuses to say, you see, I knew you were drunk.
I think you can argue it both ways, but I want to give them the benefit of the doubt because I believe the purpose of the exam is to determine, well, actually, I don't believe, I know. The purpose of those exercises is to do exactly what a Terry stop is, to confirm or to dispel the suspicion that there is impairment. That's the purpose of the test. So
you're not only saying they do it nefarious, let me be clear. They're not doing it on purpose.
Yeah.
I think it's just the nature of the job.
Well, whatever the case is, if you're behind the wheel of the car and you smell of alcohol and your eyes are bloodshot and watery and your speech is slurred, in other words, if you look like a drunk and you act like a drunk and you smell like a drunk, you're probably drunk. So those two, I think, are real nice and kind of work together. How about don't compare apples to oranges? That was one of your suggestions today.
I love it. Tell me how many
Why'd you throw that one in?
I had a guy just today, right now, right before this, I called one of my clients telling me about how he pulled a knife on a cop in New York. This is a situation here where he got into an argument with the manager of a restaurant, and the manager and him has always had problems. He was a customer. He kicked him out, and my client went out, but he's got a bit of a temper, but he's just old school. Doesn't like people disrespecting him and thinks he needs to take it upon himself to teach them to respect him, right? You know those guys. I may or may not be one of them. But he walked out. He walks out of the restaurant, and the surveillance footage shows him turning around and kind of taking a few steps back and arguing with people. And then the manager called the cops on him and claimed that he had a screwdriver in his hand. They never found the screwdriver, and he got arrested for that. He got arrested for that, ag assault, because the guy said, the manager said he had a screwdriver. So he's sitting here telling me how in New York he pulled a knife on a cop, and like 15 cops beat him, and he fought back with the cops. And in that case, the case charges were all dropped. Every case is different. In his own words, in that other case, they had no surveillance footage. They had no evidence other than a couple of cops testifying against him. And he said it never happened. But Michael, as you and I both know, prosecutor may have more cases. He may have had already credibility issues with that cop because he knows him. There's a million different things. You can't tell me.
Plus, it's New York, so he probably was out on bond in 3 seconds, not even on bond, just got
Right.
let go, and who cares what the cops say anyhow in New York?
Right, but even if it's here, and this is what people need to understand, when you're hiring a lawyer, don't tell us about any other cases. Don't tell us about the jailhouse lawyer in there telling you about other cases. Every case is different. And if I may, Michael, agree or disagree with me. One, the facts, all different. Every case is different on the facts, and it depends on whether some of these facts, there's usually different elements to a crime, and some of the facts in your case fit all the elements perfectly, but in the other case, they were missing a couple of facts for one element only, but that's enough to defeat the case. Number two, every case has a different prosecutor and a different judge, and that also matters. Not in an unethical or nefarious way. It's just, am I wrong, Mike? The prosecutor and the judge matters.
Let me explain it this way, because it's similar to what you're saying, and I go through this regularly. I get calls from people all the time, and one of the first questions that almost everybody wants to know is, how much is it going to cost? In fact, many people want to know that before they even hear anything else. They want dollar. I got arrested for DUI, how much? So I go through this all the time, and it's real simple. As you said, every case is different. Don't compare apples to oranges. If Ed and I, we both get arrested, God forbid, both get arrested for DUI tonight, okay? They're going to be by different police officers. They're going to be under different circumstances. One of us may be sound asleep at a red light. Another of us may have been speeding or weaving or ran over a baby. One of us may have open containers or controlled substances in the vehicle. One of us may have underage minor children in the vehicle. One of us may have a prior DUI or arrest history. One of us may have a horrible driving history. One of us may have multiple DUIs. There may be an accident involved. Certainly going to be a different police officer. One of us may have taken roadside sobriety exams, the other not. One of us may have taken breath, one of us may have refused. There may be an issue with the breath machine, there may not. All of these types of things, plus dozens and dozens of others, which I haven't.
But I want to add a very important one. One of us may have had a big mouth. Which
statements, admissions. There are also extra, like you and I did an episode on collateral consequences, right? One of us may pick up additional charges for resisting or obstructing or fleeing. So anyhow, regardless of any of that, let's assume that it's even very similar. Let's say we were both stopped for speeding. We both refused breath but took roadsides, and neither of us have any prior history. We still are two sentient different people in two different shoes with two different officers, two different prosecutors, two different judges. So these things all combine, and I can't ever tell somebody I charge X for this charge, because the arrest charge is irrelevant. Well, it's relevant, but it's irrelevant to the fee quote. The fee quote is based on what it is that we believe we can actually accomplish, what we agree to as a litigation objective, in light of the amount of time, effort, and energy that it's going to take to realize that objective. And so your DUI and my DUI, while they're the same exact charge, while they face the same exact penalties, mine might be a $10,000 case, yours might be a $2,000 case. There's just no way to know without digging into those unique properties so that we don't do the adage and compare an apple to an orange, right?
Yeah.
How about here's a good one that we get, speaking of when we talk to clients or potential clients. This comes up an awful lot. I get it on Avo in questions very frequently. I'm going to give you two at the same time. One, a little knowledge is a dangerous thing. And we couple that with he who represents himself has a fool for a client. So really what we're talking about here are those folks who know just enough to be dangerous to themselves and to screw up their own case.
The jailhouse lawyer or the Google lawyer. I love the Google lawyer.
Or the Facebook lawyer, right?
Yeah, they know
Facebook
it all.
law degree.
Right? Exactly. It's a problem because what happens is, for example, again, you may read a statute and you may say, hey, I could understand the elements of this crime. There's 3 elements. It's pretty simple. But the problem is, like everything else in the law, and I don't know if this is done intentional so that lawyers can charge a big fee or not, but nothing in the law is what it appears to be. Nothing in the law is common sense. So when you read things and you think, well, that common sense, that's what that means, that doesn't mean that that's what it means in the law. And you need to understand the law to understand how we have to interpret these things.
Well, and the other thing with that is, words are plain and simple. So I had a question on my YouTube channel today on a video about improper exhibition of a weapon. And somebody asked about, what exactly does it mean? Because I've read the statute and I don't understand, right? The statute says that you are in possession of a weapon or a firearm and you display it in, quote, a rude, angry, careless, or threatening manner. That's it. But it doesn't define what is rude, careless, angry, or threatening. I mean, most of us know what threatening is, right? But how do you quantify or define rude, careless, or angry? And so what I had to explain to this individual, which is exactly what you were just saying now, is the statute is not meant to interpret itself. It's simply a guideline. And the interpretation of that guideline is made by judges, juries, and appellate courts. Those are the ones who decide what is rude, careless, angry, or threatening in this particular case. And did that behavior rise to that level?
I'm going to give you a real world example that I can show them right now. In that same statute, what's a weapon, Michael?
You mean a dirk or a metallic object?
The common sense would say.
A dirk right here, Ed.
Right? Look, common sense, if you're a common sense kind of person, you're not a lawyer, you would say it's a bat, a knife.
What about this? Is this a weapon?
Well, I'm going to give them what the definition. Yes, it is. And I know, and this is why. So is this. You know why? For all you guys watching, I know Michael knows this.
The just depends what you do with it.
A definition of a weapon is something that you use for a manner other than the manner it was intended to be used. That's it. Coupled with, what is the definition? Rude. What is it, Michael? Read it for me again. Rude, angry, threatening.
Rude, angry, or threatening, or careless.
Right. So this is not a weapon until I tell Michael I'm going to bash your fucking head in with it.
Well, you don't even have to tell me. You just have to. You just have to. Actually, I can use another one of our adages here. I can use another adage here. Actions speak louder than words. You don't have to say shit. All you have to do is do something angry, threatening, careless, rude. I mean, rude is the standard, Ed. You're screwed 6 ways from Sunday, bro. Well, you got no shot. You need a priest, not a lawyer.
I would argue that I have to interpret what rude is. But here, this Cup could be a weapon, which, really the way they play lately should be considered a weapon for the fans. But it could be considered a weapon. So don't sit here and try and tell a lawyer, anybody, listen, seriously, the minute you graduate from law school, you already are starting to think more like a lawyer. And it's really detrimental to your own defense.
You can think about it this way. I mean, let's take lawyers out of the equation. Okay, let's just put it this way. So you're about to board your flight to Tunisia when you decide to go into the cockpit and tell the pilot how to fly the frickin' plane. You're about to undergo open heart surgery, but before you have to consult with the doctor and make sure that he knows what he's doing because, you don't want him, not doing anything that you're not right. You need to make sure that he's on top. In fact, don't even anesthetize me, doc. I need to make sure what you're doing right. I mean, this is how ridiculous and absurd it is. And I understand it's different, especially when we have clients who are in custody. Clients who are in custody have all day to sit around and think about the fact that they're in custody. They're not
Right.
happy.
They
It
got nothing
really
else to do.
sucks. I mean, it is one of the worst feelings that you could possibly imagine. You're helpless. You cannot do anything for yourself. So, another issue that comes up, obviously, we have clients who are in custody, somebody's got to pay the bill, right? The guy sitting in the jail cell can't write
Right.
checks or do electronic transfers. So, these are, it is a limitation. So you're sitting in jail all day long, 24/7, day after day, week after week, sometimes month after month, hell, on death cases, year after year, right? And no matter what, we can't speed up this process. It's going to take its natural course. And even if we are fast, it's still always weeks to months, even in a best case scenario. In fact, I'll hit that adage next after this
I
one.
was just going to say, we got one coming up for that.
But it still, takes a good deal of time. So while these people are sitting in there, as opposed to going to work, as opposed to spending time with their families or taking their kids to t-ball or, doing whatever it is that they need to do to function and pay their bills, they're trying to figure out, how can I get the hell out of here? And so they start yapping about their cases to their co-inmates.
So they're bunkies. They're called bunkies, Michael.
Bunkies, right. Cellies.
Cellies and bunkies.
They start talking, which, number one, is always a horrible idea, because if any of you are ever in jail, even if it's only for 5 minutes, even if you're only waiting for bond, much less anything longer, recognize this. Every single person in there is either a snitch or a potential snitch.
Which we have an adage for that too.
We have an adage coming up for that one too. That's true. So while these people are sitting there and they're talking about their cases, there are people that have been in the system long enough to have become what we call a jailhouse lawyer. And sometimes you even have actually legal trained people who are in the jail, right? I have a paralegal that I do work with who served time on a murder rap. And this guy actually spent 12 years in prison. And he is just smart as can be. And from inside and the outside, he knows the system better than most of us. So if you were sitting in jail and you had a guy like that giving you advice, at least you were getting good advice. But the vast majority of people in jail that are giving advice don't have any legal training or experience, and they're operating on what they believe and what their own physical world experience has taught them, which may be valuable, and I don't want to discount it, but still, they're not your lawyer. Your lawyer is your lawyer, and that's the person who needs to steer your ship. And if you're not happy with that captain or you're not comfortable with that captain, get another one. There's plenty of us to choose from. Just don't rely on the guy, in cell block C1, because that's not.
If he was that smart, he wouldn't be in a jail cell.
More than likely.
More than likely.
So where was I going to go from that? What was the one that I was going to go to from that?
I have no idea. We got a bunch of them. We could talk about speeding trials up when clients want to speed the case up.
That's where I was going to go. So where did I do that? Where did I have that one?
Keep looking that up. I'll start talking about it. So he'll come up with the idiom or the saying. But one of the worst things, and I can tell you from a prosecutor standpoint, right?
Here it is. Slow and steady wins the race, a.k.a. the early bird gets the worm.
Now,
so we have those two.
Right. Here's the deal with slow and steady wins the race. As a prosecutor, I can tell you, especially on cases where there's civilian victims, every day that goes by that you're not in trial is bad for the prosecution. Okay. And I tell this to my clients all the time. 9 times out of 10, most of the times, when you're arrested, that's as strong as the state's case is going to get. But is that not a true statement? Most of the time. They've done their work. They've gotten all the evidence they can get, and they're going to arrest you. They have done it. They're done. That's it. The only thing that can happen from there is shit starts falling apart. People die. People move away. Cops retire. Memories get faulty. So why are you in a hurry? Unless you're sitting in jail, why are you in a hurry? I get it. You're stressed. You go to sleep every night thinking, what's going to happen? Am I going to go to jail? Am I going to go to prison? Are they going to give me a plea? That's really wearing on you, and I get that. But you're making a mistake if you're trying to force something to happen. Slow down. Take it easy. It only gets worse for the prosecution.
So that is a very true statement in many cases. On the flip side, it's also true that in many cases, because prosecutors get a new case or series of cases dumped on them literally every day of the week. It is a never end. Imagine that you never shut your faucet, right? The water constantly flows. That's what happens with new cases. And so if prosecutors are not closing out cases as quick as they're picking in new ones, they get buried under the weight. And that is the counter argument for taking your time and going slow. Because if you force them to deal with stuff in the moment, that's other stuff that they can't deal with because they're stuck dealing with you. Some cases that works to your advantage. Some cases it doesn't. So, I think different lawyers have different philosophies about that. And I think it is very case specific and prosecutor specific.
And here's the thing, if I may, Michael, because you're right, you're 100% right. But I think the best way to describe it is this, which is another thing I like to tell my clients. What we do, especially in criminal, is a chess game, right? So we start the game off, and imagine you start the game off where the prosecution has their full board with all their pieces, and you're missing half of your pieces, right? Because you're at a disadvantage when the case starts. But you start moving, and you start taking a pawn from here, and a bishop from here, and a rook from here. When you see that the moment is right, when you see like, oh, I got them on their heels, you go for the jugular. That's when you do early bird catches the worm. That's where you file your speedy demand. That's where you start saying, no, I don't want any more continuances. No, judge, I object to them having another continuance. When the moment is right. But since normally we start at a disadvantage, you can't just jump in and get it over with because they may still have a lot of their chess pieces on the board, and you're stupid for trying to do that.
Again, it depends on the case. I mean,
right.
My normal philosophy is, I err on the side of going fast. I believe in the stick and move philosophy of criminal defense. And I think it's very difficult for prosecutors to keep up with that pace. I wish more lawyers did it my way and less the other way, because you wouldn't have 5-6-year-old cases with 10 continuances and pissed off judges. You'd have prosecutors chasing their tails every minute of every day if more lawyers were more aggressive. But be that as it may, you're right. It's completely case specific. And some cases it works, some cases it doesn't work. But let's give an example, because you had this happen to you amazingly 2 times in 1 week in 2 separate cases that have nothing to do with one another, with 2 separate police officers. You have 2 cases right now that are going on where the lead police officer, the most essential witness in the case, is under investigation by the state attorney's office.
By the very state attorney's office that's prosecuting my client, correct. And now, again, what do I got to do? Now I'm going for the jugular, right? Now I'm trying to see what I can do to get this case to trial. But keep in mind, guys, there's another thing that's important to explain to clients. We still have an ethical obligation and an ethical duty to do it a certain way. At least for me, there are some lawyers who do this. I am not going to lose the credibility that I've taken 20 years to earn with the judge and the state attorney's office by saying something that is wholly incorrect, that I know that only a dumb judge would grant me. But then later on, when that judge talks to other judges, he's going to find out that I lied to him just to get it out for my client. I have to do what's right. So, for example, on one of them, Michael, I filed my stand your ground motion. Obviously, this cop doesn't want to testify at all for anything. So he's going to plead the fifth on everything. The state keeps asking for a continuance. I keep telling the judge very respectfully, I understand, but how long is this going to go? We've done that for 1 or 2 soundings. Now we came up to the 3rd one, and now very politely and professionally, I said, Your Honor, I think enough is enough. And the judge said, you know what? I think you're right. Why can't we have the stand your ground motion? So now I offered to the court, give us 5 days, give the state 5 days to prepare a motion so they can have case law. I'm going to look for case law. Why do I do that, Michael? Because I'm very confident in my abilities. I know that I can, if the law exists and it says that we should go forward, which means they're going to lose. Because if they go to stand your ground motion, they got to prove my client wasn't defending himself. And the issue that my client has as a stand your ground motion against a cop is that the cop didn't identify himself and my client didn't know he was a cop.
Well, he's an essential witness to the case. So
how do you prove that my client didn't defend himself? The cop has to testify. He won't testify.
This is what I call a case-specific strategic decision. Here you have a situation where you have a essential state witness who you have very good reason to believe, probably every reason to believe, is not going to testify because he himself is under investigation and potential indictment. And so he doesn't want to get on the witness stand and have anybody ask him anything. And if you were his lawyer or I were his lawyer, we would be telling him the same thing. Don't
Correct.
answer any questions. You honor your subpoena, unlike Steve Bannon, show up and then just say no, but show up, right?
Right. Show up and say, I plead the fifth.
I can't say anything. I'm sorry. I got nothing to say. I mean, Bannon could have done that. He could have shown up and said executive privilege, executive privilege, executive privilege, and there's nothing they could have done. He wouldn't have had he might have had a criminal referral, but I don't expect that they would have filed a charge against him had he shown up and simply invoked. Right. So, those are some, good.
And I want to make sure that the clients, anybody who's listening, if you're a client, you got to understand something. You want to have a criminal defense lawyer who is respected by the state attorney's office and the judges. You don't want to have a guy who's a loudmouth and just yells and screams because it's actually hurtful. They talk and they're professionals and they take it personal. You have to be respectful. You have to do things the right way. And sometimes, like I said, look, like again, when I used to pitch, anybody, a guy who throws 100 miles an hour fastball, he doesn't have to fake. He doesn't have to put a spit on the ball. He doesn't have to do any of that. He can look at the guy hitting and go, here it comes. I'm throwing a 100-mile-an-hour fastball. Let's see if you can hit it. And the guy batting will respect him, even if he strikes him out. But when you start cheating, nobody respects you. And then you get a bad reputation. And you don't want to have a lawyer who's got a bad reputation because even, once again, to go back to the first one we started with, you got a lawyer who acts like that, who lies and cheats and disrespects, he's crying wolf. Then when he represents the next guy, anything that comes out of his mouth, nobody believes him. So you don't want that because they're not going to believe anything he says. And the prosecution, look, it happened to me when I was a young prosecutor. There was a defense attorney who was extremely rude and disrespectful to a colleague of mine. And for the 6 years I was in that office, I made it a point to give that guy hell. I didn't do anything unethical, but I can guarantee you he didn't get any favors. Not one favor.
Discretion.
All
right, how about this one? Let's do a twofer. Don't do the crime if you can't do the time, dovetailed with it's only a crime if you get caught.
Which really is true. I mean, I hate to say it, but it's true. If you do a crime and you don't get caught.
So remember we talked about we talked about the Boy Scout motto, right? And the law of the 7 Ps. Look, we don't encourage people to commit crimes. We don't aid and abet people to commit crimes. We don't tell people how to get away with crimes. If you're going to try and plan to do something illegal, at least plan it out as best as you can. I mean, if you do it recklessly and foolishly, obviously you're going to increase the odds of getting caught. So if you don't get caught, you get away with it. Technically, was it a crime? Yeah, but are you going to be held accountable? I mean, I guess maybe, you know what I mean? But, in the moment, you're not going to be held accountable by a judge because you've never been nailed. That said, going into, I mean, it may not register with a lot of people because I'm not a gambler, okay? I can go into, I don't go to casinos, but if I went to a casino, I wouldn't wager a dime on anything because I'd rather set my money on fire than risk losing it that way. It doesn't work with me. But if I were a gambling man, right, if I were going to bet, I would have to wager that I was going to get away with something worthwhile to put the effort into it to do it. So if you're going to commit a crime, whatever that crime may be, if it's an intentional crime, I'm not talking about something negligent or reckless that you didn't think through, but I'm talking about something you think through. You need to keep it in the back of your mind. I might get caught. If I get caught, I will get prosecuted. If I get prosecuted, this is the type of penalties that I'm facing. And of course, going back to our discussion of a couple of weeks ago about collateral consequences, it's not just jail time. It's stress, it's aggravation, it's anxiety, it's family issues, ripples through your finances, your emotions, professional licensing, all that sorts of bullshit. So you got to weigh that, right? Don't do crime if you can't do the time. Think about what you're doing before you do it, and then do your own cost-benefit analysis. if you're going to take that $1,000 or that mortgage payment and go to the casino, are you really prepared to lose it? Or are you that blindly focused on the fact that I can't lose and I'm going to win for sure? Because if that's the case, then, many of our clients think that way.
There's three things I want to add here. Number one, if you think you're never going to get caught, you're a fool. I used to say the prosecutor's favorite sin should be greed, because that's why we catch most of the people. Most of the clients that I had or defendants that I had as a prosecutor were caught because of greed. They usually it's not the first time they committed a crime, especially that specific crime, like let's say the drug dealing. When I caught a guy trying to buy or sell 2 kilos, well, the first time he was trying to buy or sell cocaine, he started like everybody else, probably sniffing himself, then trying to just, sell to be able to pay for his own supply. Then he saw, man, I can make some money. He started getting greedy, sold a little more and a little more. And the next thing you know, he's selling to a cop or a CI. Number two, I had a client once that only got caught with, 28 grams or less is
Coke?
person? Yeah, cocaine.
Coke?
Yeah, I think it's
28 grams of the cutoff.
He always used to tell me, listen, I always only have 28 grams on me. I never have more than 28 grams on me, because he knew that if he had a larger amount, half a kilo is a 15-year min-man. He knew if he only had half a kilo of cocaine, 28 grams of cocaine, no matter how many times he got arrested, he probably would always get probation or credit time served. So he always had just the right amount, because like you said, he knew he couldn't do 15 years. So he knew that. And lastly, I don't understand about our clients that are in a continuous criminal endeavor: drug dealers, fraudsters, Medicare fraud.
They'll never get caught, Ed. They'll never get caught.
Not only you'll never get caught, they've been doing it for like 2 or 3 years, let's say, or a year. And over the span of a year, they've made $4 million. But when they get busted, they got no money for a lawyer. If you're going to do it, plan.
Well, it's a good thing you get paid in bananas and firearms.
But seriously, plan ahead. Save some money.
We're running slow, and I want to hit running quick, and I want to hit a few more. So let's jump into this one. There's several ways to say it. So I'm going to give you all of them that I can think of in the moment. The first is the general idea: loose lips sink ships. You could also say, don't let the cat out of the bag. Don't wait to close the barn door until the horse is already bolted, or you'll never see a fish on the wall with his mouth shut.
Yep.
So all of these things kind of relate to the same topic. And there's an acronym that Haber PA uses called #UpX2. And it stands for up times 2, meaning shut up and lawyer up, meaning invoke your Fifth Amendment right and your Sixth Amendment right, meaning invoke your right against compulsory self-incrimination and your right to counsel. Don't engage with the cops. Anything you say can or will be used against you. Conversely, if you don't say shit, nothing can be introduced against you verbally anyhow.
Nothing you
say. They can still report on what they observed, your actions, your demeanor. Oh, Martinez didn't say anything, but he looked guilty. That's not coming in. The judge ain't letting it come in. Prosecutor may like it, but
I'll tell you one that doesn't come in that goes even further. Call your lawyer. For example, Michael, you're the cop. You want to find out what my client did. Ed, accusing your client of breaking into this house to steal something. I go talk to my client and I come back to you and I say, listen, Michael, client says he didn't break in to steal anything. He says that the owner told him to go in because he owed him money. And the owner said, listen, I don't have it. Go in there. I got a statue of whatever that's worth $500. You could take it and sell it. Right?
It's a great statement, and it's thoroughly inadmissible.
Thoroughly, because I said it.
Right.
It's hearsay.
So what I try and tell,
let me tell them what they understand. So they understand. The cop gets what he wants, which he wants to hear your side of the story. Maybe 9 times out of 10, they just want you to confess. But maybe he wants to hear your side of the story. He gets to hear your side of the story. But if he still decides to arrest you, he can't use it against you. He cannot use that because it's hearsay. I'm saying what he said, and they can't use it at all, especially since I'm your lawyer. They can't touch that.
That dovetails with anything that you can say. Your lawyer can say both safer and smarter.
And smarter.
So
right. Because, for example, if you say, hey, Ed, The guy told me to go in, but he told me to crawl in through the window. I'll be like, yeah, we probably should be telling him you crawled in through the window. Let's hold off on that
There's-
one.
So I think we can say as a general principle to people, less is more, and the acronym KISS, keep it simple, stupid, that applies very much to any police citizen encounter. The less you say, preferably nothing, the better.
Nothing.
And now listen,
and call your lawyer. Call your lawyer early.
Let's not pretend or ignore the fact that there are circumstances where you might be able to talk yourself out of a traffic ticket, or you might even be able to talk yourself out of an arrest. I'm not saying it's impossible, okay? I'm just saying that the overwhelming odds are you'll do more damage than you will good, and you can protect yourself by calling your lawyer and having your lawyer do it instead of you, right? And that kind of dovetails with another one that I think you suggested this morning. You get more with sugar than salt, or you catch more flies with honey than with vinegar, right?
Correct.
So when you do talk to law enforcement, when you do engage, be respectful, be polite, don't be a dick. Don't tell the cop who pulled you over what your rights are, okay? You can know your rights until you're blue in the face. Doesn't mean you need to give the officer a lecture on criminal procedure. It's just going to put you in a bad place. And similarly, the same thing applies to Ed and I and to lawyers. There are times where we go to war, okay? And I will call it war. We don't use weapons, but we use words, and we use paper and pens and computers, and it may as well be, a medieval battle, because that prosecutor is trying to slit my throat and murder me just as bad as I am him or her. We want to win. But we also recognize, as bad as we want to win, that you do get a lot further with sugar than you do with salt. And a lot of times you can still fight that fight and do it with a smile on your face and professionally, as opposed to being a jackass or a douchebag. So there are times where it happens, and again, I don't even think it's necessarily always inappropriate for you to be aggressive or even hot under the collar. Correct. But overall, as a general rule, and especially for civilians with cops, keep it cool. Be cool. Act cool.
And you don't want a lawyer, like I said earlier, who starts, because the example I like to give my clients is this, especially when it's a male client. I have a different analogy for women, but I'll use the one I use for men. I say, suppose you go to a bar, restaurant bar, like a nice bar, and you're sitting at the bar with your wife having a drink, and you go to the bathroom. You come out of the bathroom, and there's a guy sitting next to your wife on your bar stool, right? Now, you could go up, like some lawyers would, and just start telling the guy you're going to beat his ass and punch him and throw him off the bar stool. Or you could go up and say, excuse me, that's my bar stool. And perhaps he'll say, oh my God, I am so sorry. I didn't know you were. I just walked in. I saw an open stool. Beautiful woman sitting here. I thought, why not? I got to take a shot. I am so sorry. I apologize. Let me buy you a drink. Nothing happened. But by the same token, suppose I walk up and he says, I say, listen, you're sitting in my bar stool. That's my wife. And he says, yeah, well, I don't give a shit. Screw you. I'm going to fuck you up. Well, now I can punch him, right? Now I can go to war. There's always time to fight.
I don't know if that's going to be a provocation that's going to satisfy a reasonable use of force.
Depends. But you get my point. The point is, there's always a time to fight.
What I want to know is, what's your example? What's your example for women, you misogynist?
We don't have time. But same thing. I mean, women get into fights over bar stools too. But, the point is, your lawyer, you always have time to fight. And so the best strategy is to start nice, go up to the prosecutor, be nice, be respectful, be polite.
Well, like you said a few minutes ago, you had a criminal lawyer who for 6 years got the worst of you because of his own actions.
Right.
Let's get through these last.
For example, like you. So the audience will know. For example, with you, why did I always treat you respectfully? Why was I always willing to give you everything I could, reasonably, ethically? Why?
Because I paid you off.
Well, if you did, I don't know where you put the money, because I was broke when I was a state attorney. But no, because you were professional, you were polite, and you were respectful. Even if you thought I was unreasonable in my offer, you would just tell me, Ed, respectfully, I think that's unreasonable. Okay, Michael, I agree with you, but we
were able to, because we communicated. Okay, I mean, that's the truth. We communicated. Let's get to our last couple of adages, expressions, sayings, whatever you want to call them. because I got 4 more and we got about 10 minutes. Snitches get stitches, aka talk shit, get hit.
Like if you're sitting at a bar stool next to my wife and you talk shit,
well, I'm thinking more like we were talking about when you're in jail and everybody's a potential snitch. If you ever get arrested with co-defendants, in other words, you're not the only person arrested for a particular incident. Like Ed, the example Ed used earlier about the guy he played ball with, the pothead who hit 400. If those two got arrested at the same time, they are each potential snitches against one another. So the expression snitches get stitches or talk shit get hit really refers to the concept, and to some people, yes, to some people, no. Some circumstances it works, some it doesn't. But overall, the idea is keep your mouth shut, worry about yourself, and if you focus on you and a little less on everyone else, you're probably going to fare better. Now, of course, there are some circumstances where snitching, is inevitable and it's going to happen and it's dealt with. But if you are a snitch, prepare for the potential reasonably foreseeable consequences of your behavior.
I always say this. I am no one to judge anybody's position. I don't know how they live their life. I know how I would live my life, and I judge no one. So do I have clients that want to flip and testify or snitch or become CIs? Of course I've had. Do I judge them or treat them or respect them any less? No, because I don't know, Michael. I don't know what's going on. I could see a situation where, we are lifelong friends and I've saved your life multiple times and we decide together to get involved in a criminal endeavor and then we get arrested and you snitch on me. Because I put you out. For example, let me backwards. I've saved your life a bunch of times. You say, hey, do me a favor. Yeah. Can you come with me? I got to go pick up a car that some guy's giving me. And then you end up stealing the car. But with me present, not knowing you were actually stealing it, we get arrested and then you try and tell the guy that I did it. I could see me being pissed off at me like, you know what, Mike? Fuck you. I'm going to snitch on you, you fucker. I don't judge anybody. But just know that if you're going to do that, there are consequences. Also know this. Very important. Don't think that because you become a snitch, all of a sudden you're like, on their team. They still regard you as a dirtbag. They still regard you as a defendant. They still regard
the government and the police.
The government and the cops. When you become a confidential informant, I have to tell this to my clients. Don't think that all of a sudden they're going to be like coming to your house for your birthday and playing.
Well, oftentimes they start out like that. That's how they butter you up by telling you you're going to be your best friend. And then all of a sudden you're their bitch, not their best friend.
I used to tell them, we'll get 30 seconds. When I was a prosecutor, because you don't mind me, Michael, I like to be upfront and honest, brutally honest. When these guys, the cops hated when I did this. When we used to sign them up as CIs, I used to look them right in the eye like I'm looking you and say, make no mistake, you are making a deal with the devil. Nothing would make me happier than for you to give me all the cases you can give me. And on the 11th hour, before I'm going to give you probation on a 15-year min-man, you violate. Would make my day. I'd go out and have a cup of coffee. We are not friends. So you need to understand that's their mindset.
But the cops never say that. You will never hear that out of the police.
They hated me for that. And you know how many times they didn't sign the CI contract? How many times they said, in that case, I don't want to sign? Every time they signed anyway, because they have no choice.
Right. Well, but you're dealing with things like that. It's different. Let me get to the last two. This one is near and dear to both of our hearts. You get what you pay for.
Oh, yeah.
So anybody who has ever received a ticket here in South Florida has gotten a bunch of things in the mail because there's, ticket mills. There are traffic lawyers that buy the lists on a weekly or a monthly basis or a biweekly basis from the clerk of the court, and they bulk mail every single person who got a ticket. They do this.
If you got a ticket or a DUI, you've seen it. You've gotten that bulk mail.
Any ticket. So, but if you get the ticket, it's also going to talk about DUIs because these guys know that some percentage of DUI cases are going to sign with them if they advertise them for $249 or $499. They do everything on flat rates, exactly the opposite of what Ed and I were talking about earlier. And in fairness to them, when you're talking about a basic traffic ticket and that's all that you do, and you're in that courtroom or you have people in satellite courtrooms handling these things, it's very easy to flat rate them because it's a bulk business. But criminal charges are different than traffic infractions. And so people who wind up signing 249 or 499 for a DUI without anybody asking any questions, well, guess what? You're going to get what you pay for, which is a quick plea, because that's all that's going to happen in that case. There ain't going to be any diligence done.
Notice all they do on these ticket clinics is what, and there's a very good, don't get me wrong, I'm not criticizing them at all. They've got a very functional job and place in the criminal justice system. But notice all they do is they advertise that they can guarantee you no points, right? Guarantee no points, which means all they have to do is negotiate a withhold. So let me explain to you on the traffic tickets how this works. If you don't want to spend two times going to court, 3, 4, 5 hours a day out of your day just to go to court, to end up paying the ticket anyway, or trying to see if you can get it out, but at the end of the day, whatever happens, you might have to pay it. It's worth it to pay $69, $79 to let somebody else go for you. The judges appreciate it. Why? Because instead of dealing with 20 civilians that don't understand how the system works and it bogs them down and they got to explain everything to you, they got a guy sitting in the courtroom. When they call a name, Michael Haber, are the officers present? Yes, they're here. Change of plea, Your Honor. Okay, withhold. That's how fast it goes.
And a lot of times they're all worked out in advance. I mean, these lawyers
Correct.
sit in the courtroom, they talk to the cops before the calendar.
Right.
You know, there's a million good reasons for it.
They've got their
Let me give the last
fight, wait, but this is the important part. But if you want to fight, if you want somebody who's going to fight for you to the tooth and nail to the end, and you really want to put up a fight on this case, that's not the guy who's going to fight for you. And if you think, again, you've got to ask yourself, you know more or less what a thing costs. You got friends, you can ask around, you can look around. If somebody says $5,000 for a case that every other lawyer in town is charging you $15,000, $20,000, $25,000, $30,000, it would be like me telling you, Michael, I'm going to sell you a 2021 Ferrari, but I only want $30,000. First thing you're going to say is, why so cheap?
If it looks too good to be true, it's probably not true.
Correct.
Could have thrown that adage up there. So let's, bear that in mind in terms of skill, experience, and quantitative analysis that's put into quoting fees. And then the last one that I want to do is a two for all. So it's the golden rule. Most of us learned the golden rule as, young children. It's an ethical directive or a moral maxim: do unto others as you wish others to do unto you. But there's also a corollary golden rule in the court context, and it applies in both civil and criminal court. And that is a prohibition that does not allow a lawyer to ask a jury or a trier of fact, generally a jury, to put themselves in the shoes of the aggrieved party. So if you're a criminal defense lawyer, you're not allowed to say to the jury, imagine that you're Kyle Rittenhouse and what you were thinking. Well, actually, you can when you're talking about self-defense to that extent.
Self-defense, you can.
But in normal circumstances, you're not allowed to do that. In a civil case, the corollary would be you're not allowed to say, imagine you are, my client who's the mother of this poor child that was killed, by the police officer. Right. So you just, that's called a golden rule violation. Anyhow, the golden rule: do unto others, or don't put other people in. Don't ask the trier of fact to go into the circumstances of the aggrieved party. Either way, it's an adage that applies. You want people to empathize with you and understand your situation. Treat them the same way, okay? If you go into the courtroom and you're asking a jury to acquit you, don't sit at the counsel table snickering or making snarky faces or, calling witnesses liars or standing up. You got to comport your behavior to the moment. When I try cases, it's always with another person, another lawyer, usually with Mark, or with you or whoever. But the point is, there's two of us, okay? One of us is handling the actual witness in the moment or evidence in the moment. The other one is doing client control and monitoring the jury and the judge. So it's very important that the clients constantly be held like, almost, I hate to say it, but like a dog on a leash. You've got to keep them contained and make sure that their behavior is appropriate. You can't just take off the leash and let them run through the park and do whatever the hell they want. It's going to be a problem.
Correct. And let me tell you, I've done a lot of cases by myself. Even as a prosecutor, I did a few by myself, which It's rare because there's so many people in the office and everybody wants to have a trial under their belt that it's usually easy to find somebody to go second chair. But on the criminal defense side, I've done a lot of trials by myself. And you're absolutely right. You guys, as a client, you got to understand it's very distracting when you're leaning over, yelling in my ear, he's lying. Write it down on a note.
Like we don't know that.
Right. The cop is lying. I know. But leave
But
me
it's
alone.
even worse. But it's even what's even worse is, again, actions speak louder than words. The jury may not hear what you're doing, but you're now making a big deal out of it because they're looking at you, right? They're not looking at the witness the minute that you start making a scene in the courtroom as the defendant. They're immediately focused on you.
And just leaning over the
even a
whispering in
small
the ear is a scene.
even
They'll
a
look
small
over.
and even a small innocuous point can be made very big and given a lot more power than it ever had. It's one of the things that we learn as lawyers. Certain objections, let them go. Don't even make them, because all you're going to do is highlight that particular moment of time, and maybe some juror is going to think back and go, God, man, that Haber, remember when he jumped, they're sitting in deliberations, right? And he says, you remember when he jumped up and objected and he got into it with the judge? He goes, wow. And that's what they were talking about. This at that, all of a sudden it creates an extra significance to something that was really probably nothing in the first place.
Which brings us to another point. Same on the side of the road for lawyers, and I don't want to give away too much of my techniques, but this I can say: why not make a big deal out of it if you don't have to? Same on the side of the road, because that's not the place to win that argument. The place to deal with that is in closing argument when the witness is not there. He can't answer to it. He can't say anything about it. Nobody thinks there's a big deal out of it. And now you have a way to control the narrative and throw it out there like, you know why I didn't object? Because this is so stupid. And let me explain to you why that was stupid. And then you get into it. I wouldn't use the word stupid, but you get it, right? Same on the side of the road. You're going to argue with a cop, you're going to lose. The place to make the argument where you want to teach this officer about Fifth Amendment rights and what your rights are is when you're standing in a courtroom in front of a judge.
And it's not you, it's your lawyer.
It's your
You
lawyer.
are not supposed to, you don't give the officer a criminal law, criminal procedure lecture. Let your lawyer do that because it's appropriate.
Can I tell you something?
Anyhow,
I don't do it. I don't do it. You know why they get mad at me? When they stop me for stupid, I get stopped for stupid stuff. I have my registration, my license, everything ready to go. And they come over and usually ask the thing that pisses me off the most. You know what I stopped you for? If I knew, obviously either I do or I don't. So why are you asking me? And then when they tell me, I say, okay, well, I disagree. Go give me a ticket. And then they get upset because they're expecting an argument. And I tell them all the time, I'm not going to fight with you. I'll tell it to the judge. Go ahead. Just give me a ticket. Do the same. Just tell them, listen, man, I respect you. Go give me a ticket. We'll talk about it in court. That's it.
I'm not sure if I'm going to agree with Martinez's advice, roadside advice there or
Why?
not. But
why?
But I am going, well, because I've talked my way out of a lot of tickets just by being patient, and letting the officer vent and then dealing with the officer on a different level. But look, again, every situation is different. Every encounter is different. Just like we talked about, every case is different. Every roadside encounter with an officer is different.
Can I tell you how I get rid of my tickets? I just got one the other day. The guy didn't even give me a ticket. I was driving down where I moved recently, and it's a new house, and it was a school zone. And I was on the phone. You know how I get, Mike, when I'm talking on the phone. I get lost. I don't even remember what I'm doing. And I'm going at least 35 or 40 in a residential, but it's in front of Gulliver. I didn't realize that was right. I think it's Gulliver. I can't even remember. But I didn't see I was in a school zone until I saw the other flashing light.
So I went
through one, and I didn't notice it. And as soon as I saw the flashing light, that I took my foot off the accelerator and I touched the brake, there's a motorman giving somebody a ticket. And he points at me and tells me to pull over. Now, in my head, I knew that if I kept going, there's no way he's going to catch me. He's giving somebody a ticket. He's going to have to jump on his bike and go. But I pulled over. Why? Because I was speeding. The guy came over with a little bit of an attitude. He said, you know what I stopped you for? I said, I know exactly what you stopped me for. I apologize. I have no excuse. I was on the phone. I didn't see it until I saw the next light. And if you notice, that's when I started to slow down. But at the end of the day, I screwed up, man. I didn't see the first light. I was talking. I was distracted. And you know what he said to me? Thanks for being honest. You didn't have to stop. And I appreciate that. I'm going to give you a warning. Go ahead.
So look, again, every case is different.
But I had my license and registration ready.
let me thank everybody for watching, because we've gone over, so we need to nip it. But I want to thank everybody for watching. I think this was a really interesting and fun discussion. I enjoyed bantering a little bit back and forth. And next week we have a guest coming. I don't want to tease it too much, but we're going to have a really a fabulously interesting show with a phenomenal guest next week. So that said, I want to thank everybody for tuning in. Whether you're watching this live or you're going to watch it later on Facebook or YouTube or on any other platform, thank you. We appreciate you. And Ed, thank you.
Thank you, my friend.
I think I can say on behalf of both of us that we look forward to seeing you next week and once again being at your service.
Absolutely.
Take care, y'all. Have a good night.